And thank you so much for sparing your time and effort. You always being very kind. So I think one can't thank you enough.
You can never say no to you, sir. As my senior.
No. For me, you are always a younger brother. I say what seniority has to do. But yes, it's very kind of you. And I must, the university will be very grateful to you for the sparing the time and everything. So that's a big issue.
Hearty welcome, sir.
Thank you, sir.
Good morning, sir. His Lordship, sir.
Good morning.
With your kind permission, may I start with the session, sir?
Yes, please do.
A very good morning.
Just 1 minute. Honorable Mr. Justice Sanjay Kaul, can we start the proceedings, please?
Sir, please, sir.
Okay.
A very good morning to the esteemed dignitaries, guests, and attendees of the international webinar. Myself, Dr. Jaspreet, feel privileged to have begotten an opportunity to moderate the morning session of the 2 days international webinar conducted by Chandigarh University, which had started on 30th January 2021, wherein we all have savored the nectar of knowledge of global experts, academicians, and luminaries across the globe. Before we actually start, a short video of achievements of Chandigarh University will be played. I request.
I really enjoy. A great honor have to speak with the public, and also having exchange teachers or concerned people. So I really enjoy. Now this university, I think, made significant contribution.
Chandigarh University has taken the lead, and we're so fortunate we are starting from this university. It has become a leader for this movement today in the whole nation.
I'm delighted to be here in Chandigarh University. This is my first visit. I'm totally impressed by what has been achieved in such a short time. And I see a lot of enthusiasm, a lot of management inside of this, and a lot of innovative ideas.
I'm astonished by the university, greatly impressed. It is really exceptional. It has far surpassed my expectations. I think there's a great future.
One must be enthralled with the great heights achieved by Chandigarh University, which is a great hub of education. Now I feel honored to very humbly invite Honorable Mr. Justice Satyendra Kumar, former Judge Supreme Court of India, former Chairperson National Green Tribunal, Chairperson Academic Advisory Board, University Institute of Legal Studies, Chandigarh University, to deliver the welcome address. Welcome, my lordship.
Thank you and good morning to all of you. As the chairperson of the Academic Advisory Board of the University Institute of Legal Studies, Chandigarh University, it gives me an immense pleasure to welcome you all today to the conference of 2021 at Chandigarh, the two-day conference which is being organized today and today and yesterday, takes up global challenges of modern times and covers various aspects related to contemporary issues and challenges which exist in the world today. Well, we have today in chair Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India. He is been the Chief Justice of one of the most strong high courts of our country, Madras High Court, which, because of his extraordinary legal and administrative acumen, he settled the issues which were long pending for that court. Justice Kaul is not tall only. His work on the judicial and the administrative side speaks taller to his height physically. I had the privilege of knowing the Honorable Judge for a number of years, and I wonder, you can find a more humane and more firm judge than him, even in the Supreme Court of India today. Amongst other landmark judgments that he has authored and spoken for the court, in the 9 judges bench of the Constitution Court of the Supreme Court of India, he laid down the law of right to privacy as a fundamental right. I think that was a real expansion, and the doctrine of judicial creativity found new dimensions in his authoring and writing that judgment. I really welcome you, Justice Sanjay Kishan Kaul, to this webinar, and thank you on behalf of the university for having accepted and spared time from your valuable journey. Well, equally competent, equally laborious judge we have from Belgium, Honorable Mr. Justice Luc Leidson. He is the head of the Constitutional Court now, as well as President of the European Judges Association. Justice Luc had done a tremendous work. He is one man containing 2 strong hats. He is a professor and the head of the Constitutional Court of Belgium. Really, normally people find difficult to carry even one hat, but he carries both of them with equal ability, proficiency, and with greater uprightness. Justice Luc, I really welcome you to this international webinar on behalf of the university and myself. Thank you for having accepted our request. Then we have the distinguished academicians from all over the world. We have Professor Tracy Hester. He again wears 2 hats. He is a lawyer and a professor. He teaches in the Houston Law Center. And he is really remarkable, and particularly on the environmental laws, where he has achieved greater heights. I really welcome you, Tracy, to this conference and thank you for having accepted our invitation. Professor Gitanjali Nayan Gill, she is an Indian settled in UK, teaches and has written various books which have got international recognition. Her contribution to different laws, including writing of a book on NGT, was really surprising that a professor sitting in Queen Mary University would write a book on the National Green Tribunal of India. I congratulate you for that, Madam Gitanjali, and welcome you to this webinar. Thank you for having accepted our invitation. Justice Priyasad Deb, he is a judge, former judge of the Sri Lankan, and now a consultant and a kind giving advice to people. He was former Solicitor General of Sri Lanka as well, and 45th Chief Justice of the Sri Lankan Supreme Court. I really welcome you, Justice Deb, to this international webinar, and thank you for having accepted our invitation. I would just inform you that we have this two-day international webinar conference, 4 sessions, which all are presided over by the Honorable Judges of the Supreme Court of India, and we have internationally known, recognized judges, academicians, professors, and is attended by huge audience. Yesterday, we had around about 2,000 attendees directly and 28,000 who reached the conference. So I think the people at large would gain from the wisdom because we have a twofold purpose of holding this webinar. One is academic progress in the university so that the students learn even during this COVID-19 period. And secondly, which is more important, is for the students, faculty, and the general attendees of this conference to listen to such eminent, distinguished glacis of experts from judiciary and academia so that they can find their way, choices, and professional activism to reach the better ends of their life and to achieve their goals. Therefore, I thank all of you, welcome you to this webinar, and may I request Dr. Midda and Professor Jaspreet now to please proceed with the conference. I again, with folded hands, thank all the distinguished chairperson, co-chairperson, and the panelists, speakers. Thank you.
Thank you so much, my lordship. Now I humbly invite Honorable Pro-Chancellor, Chandigarh University, Professor Dr. R.S. Pava to deliver his address.
Thank you very much. Honorable Your Lordship, Mr. Justice Kaulji, all distinguished panelists, and my colleagues from the university. I deem it as a great privilege to be speaking a few things about the university. I'm sure the video has introduced the university to some extent, but let me start by saying that the university, under the visionary leadership of our Chancellor, Honorable Chancellor Das Ram Singh Sandhuji, has been envisioned to be a new age, technology-driven, student-centric university. Distinguished dignitaries, these are 3 characteristics which we are following in developing this university. And along with this, we are trying to create an inspirational model of learning and teaching in this university. And I must appreciate, again, Lordship, Mr. Justice Tantra Kumarji, because his contribution in creating environment for inspiration and motivation for all of us has been of great help to us. And this webinar is a very, very important step in that direction. Honorable dignitaries, the university has many firsts to its credit. Apart from NAC accreditation and NRF, we are accredited by QS iGate, QS India, with diamond rating, and we are the youngest university to get diamond rating from the QS India. Chandigarh University has been adjudged as the Asia's fastest growing university. The university has been adjudged as the university with best placements, and I'm sure honorable dignitaries will agree that the crisis today is that the students who study in universities, are they capable of getting jobs? Are they getting some jobs? Last year, 691 companies came for campus placement with 6,617 offers and highest package of 35 lakhs, 3.5 million Indian rupees. When the number of companies which came was 360, we entered the Limca Book of Records. So we are number one in the country in terms of offering placements to the students and the number of companies coming to the campus. Honorable panelists, Chandigarh University believes in internationalization, and we are getting international exposure today also. So we have more than 300, in fact, to be exact, 308 international partners across 67 countries. And more than 1,500 of our students go every year to different universities. And we are also receiving students from Russia, France, Germany, Italy, Canada, South Korea, Taiwan, to our campus every year for a semester. The university has been doing exceedingly well in sports and cultural activities. We are number one in cultural activities out of all the 951 universities in India. And in sports, last year we won 107 medals. The university is doing, again, exceedingly well in research, innovation, and entrepreneurship. Honorable dignitaries, the university has so far filed 900 plus patents. We are nearing 1,000. And last year, we filed in a single year 346 patents, and we were adjudged number one in the country in terms of filing patents, even ahead of companies, corporates like TCS, etc. TCS, in fact, was number two. The university has the privilege of creating a mini India and a mini world on this campus. We have students from all 28 states of India, all 8 union territories, and 45 foreign countries. The university is trying to be student-centric in every sense of the word, and we are offering scholarships to the students to the tune of 330 million Indian rupees, 33 crores annually. All this is possible because we are getting blessings and guidance from distinguished scholars and performers like Honorable Mr. Justice Tantra Kumarji. And I'm sure today's webinar and the presence of all of you today through online mode, but I'm sure in the coming time, you will oblige us by coming to the campus. We'll go a long way in creating more motivation and inspiration for all of us. Thank you very much for this privilege to be talking to you.
Thank you so much, sir. Moving further, it gives me immense pleasure to invite Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, to deliver his address. Welcome, my lordship.
Thank you. Very good morning, a bright and sunny morning on this Sunday to all of you. Justice Sutanta Kumar, the Chancellor of the Chandigarh University, esteemed speakers on the panel who are professors and judges from different jurisdictions, students of the university, ladies and gentlemen. It is my pleasure to be part of this two-day international webinar on global challenges of modern times, organized by the Chandigarh University. The illustrious panel we see joining us today, virtually from different parts of the world, is indeed a way attributable to what has been possibly one of the biggest global challenges of modern times. Our experience with coronavirus pandemic and its many related facets over the last year has possibly put us all in a position to better appreciate cross-border impacts and sit up to take note of the new stresses on the already fragile global order. In this background, this webinar is an appreciable effort towards placing the movement we are in a broader context. What is an essential first step towards an effective action. The 4 topics chosen to be traversed today over broad themes of education, environment, human and migrant rights, aspects which are intrinsic to one's existence and form the subject matter of our collective aspirations as a society and as a global community. Education is primarily a vehicle with which economically and socially marginalized can lift themselves out of poverty and obtain the means to be integrated and participate fully in their communities. A necessary corollary, therefore, is to place such an entitlement within a sound legal framework. The Indian experiment with this right reached its decadal anniversary in 2019 with the Right of Children to Free and Compulsory Education Act 2009, more popularly known as the Right of Education Act, completing 10 years of being in force. A time to take stock, as also a time for reflection on how it came about being. Education as a subject matter in India has traveled the unique path from Part 4 to Part 3 of the Constitution of India. Starting out as an aspirational directive principle, the 86th Constitutional Amendment of 2002 inserted Article 21A, elevating the right to free and compulsory education to the status of a fundamental right. The legislative realization of the right in the form of the RTE Act has, of course, concretized the entitlement in the form of guaranteeing free and compulsory education for children in the age group of 4 to 16. But a statute such as RTE being in the form of a socio-legal right needs constant policy reviews, updation, and reflection. What has been significant of note in India has been the judicial intervention in policy making. Starting, of course, with the Supreme Court upholding the constitutionality of the mandatory reservation in all aided and unaided majority private institutions, a judgment which Justice Swatantra Kumar was part of, to the right to food litigation before the Supreme Court, which galvanized the government to invest and enlarge the midday meal scheme in primary schools, which in turn, it has been estimated, led to about 350,000 additional girls now attending schools. Court decisions in socio-legal matters tend to have a stronger impact in bringing about a structural and policy changes which can create the right conditions for full enjoyment of the rights. As such, they may form a part of the necessary terms of engagement in socio-legal matters. To recognize education as a multiplier which enhances the enjoyment of all others and individual rights and freedoms has been a long-standing goal of international community, as well with the universal access to learning being adopted as an objective by a range of development in agencies, including UNESCO, the UN, and the World Bank. These have provided the necessary impetus to domestic developments to also move in tandem. What is necessary today is to address the shortcomings vis-a-vis measures that can lead to de facto discrimination in keeping children out of school. Whether it be sanitary facilities for girls, gender-based violence, or quality of curriculum, our policy thinkers and legal minds need to address the larger societal barriers that come in the way of realizing a right which is crucial not just to the individual, but also to the development of the nation. When one talks about the joint strides of the individual and the nation, one cannot be amiss to speak of an aspect in which individual action perhaps has the largest possible ramification for the entire planet. With time that we have all spent at home in the last few months, I'm sure that it would have provided us with an opportunity to ponder upon the importance of protecting our environment and our planet. During the lockdown, there were several stories reported about the environment healing itself in the light of minimal human presence. The fact that our environment has been under constant strain should raise alarms of urgency and turn towards the idea of sustainable development and economics. It is my belief that the environment is supportive, yet the environment can react back. Thus, when you do violence to environment, the environment will do violence to the human species, which seems to at times forget that this planet consists of many other species, flora and fauna, and it's a collaborative effort of all to survive on this planet. The extra importance which a human race may give it to self is possibly misplaced, and the pandemic has, I think, been an ideal time to give a thought of what nature in one form or the other can do to the human species if we don't heed the warning. The world renewed its commitment towards environment protection and climate change by the signing of the Paris Agreement in 2016. The world has now turned to greater commitment towards curtailing its carbon emissions and has started looking towards cleaner sources of energy. The overutilization of fossil fuels has not only led to their significant depletion, but has also resulted in catastrophic effects on our environment. We have, however, in the recent past, seen a surge in the use of alternative sources like solar, wind, and nuclear power. While the first two are readily welcome, there have been a lot of suspicions about the nuclear energy in terms of its safety and impact on local habitation. The Fukushima Daiichi nuclear disaster that took place in Japan is one such glaring example. It is noteworthy, however, that despite this, there are as many as 451 nuclear power reactors around the world, while 54 more are under construction. There has been a looming fear of countries misusing the nuclear waste from these power plants to initiate or increase their nuclear arsenals. It is for this reason that under the 1968 Treaty on Non-Proliferation of Nuclear Weapons, the International Atomic Energy Agency conducts on-site inspections to ensure that nuclear materials are only used for peaceful purposes. It becomes essential that principles dealing with safety, security, responsibility, control, and compliance are strictly adhered to in this regard. Similarly, at home, India, we have seen both the government and the Supreme Court of India imposing harsher restrictions on vehicles that run on petrol and diesel while encouraging use of electrical vehicles. It is important to accept and concede that we have all contributed significantly over the years in damaging our environment without making any significant efforts to rejuvenate it. Climate change, the rise in sea levels, loss of flora and fauna, loss of natural habitats, etc., are just a few examples of the issues faced by humanity today. These problems are pan out differently in different geographical locations, while raising varied legal challenges as well. One such example in that of a small island nations. These island nations are today facing an existential crisis as the rise in sea level is causing these islands to sink slowly. This has not only led to a major loss of houses, properties, and other means of livelihood for local residents, but has also resulted in widespread migration and immigration to other parts of the world. It is worrisome to note, and possible point for much discussion, that the 1951 Convention relating to the status of refugees does not recognize environmental disasters and emergencies as one of the triggers to seek protection under the Convention. It is my firm belief that environmental crisis that has made the entire human race confront its very existence is a problem that needs to be solved with collective action. We will have to learn to go beyond the formal requirements of law, as that is the bare minimum, to protect, safeguard, and nourish the environment, to be able to not only exist, but also leave a better planet for our future generations. The need for adopting the sustainable model of growth, development, and progress, which is environment and climate centric, is now greater than ever. Along with compelling us to examine how we interact with our environment, the pandemic also pushed us to examine the effects of a healthy emergency on human rights and how the two competing important objectives are to be balanced. Internationally, there are 9 core conventions that protect distinct sets of human rights. These are, of course, overlaps and interconnections, but each convention has a special focus. Together, these conventions seek to make nation states signatories responsible for providing and protecting certain basic human rights of all individuals that reside in their jurisdiction. Before the advent of these conventions and the almost universal acceptance that they enjoy, human rights were still considered to be a part of a country's internal affairs, a subject that was firmly a part of their sphere of sovereignty. This approach was challenged in the 20th century, mostly in response to horrors of the Nazi regime in Germany and the international community's failure to prevent mass atrocities that took place thereafter. States had now been made internationally responsible for how they treat individuals within their jurisdiction through these conventions. However, not all human rights contained in these conventions are absolute and unfettered, and the conventions do give states a certain margin of appreciation in how to best effectuate the right or strike a balance between the competing rights and objectives. This necessarily entails that there will be some difference in the way of the conventions envisages the provisions and protection of certain rights and in the manner in which nation states execute it. And at times, the variation can be dilution. This could be due to the peculiar regional and domestic realities, including economic strength of a nation. For instance, the right to health may not be as robustly provided for in a country that has not yet developed the desirable infrastructure to do so. By allowing this margin, the conventions recognize these disparate realities, and also the domestic authorities are in direct contact with the vital forces of their countries. And so are they better situated to appreciate the social circumstances which surround the implementation of rights. The coronavirus outbreak provided an opportunity to examine the domestic balancing of the rights to health of its citizens with nations' international human rights commitments. While some nations were able to ensure that balance, a few took the pandemic to be an opportunity to expand their executive powers and trample upon the rights of its citizens. Further, the pandemic has thrown up a new human rights challenges. It showed how the right to health was being diluted domestically, leading to poor health infrastructure and overburdening, and how the response to the pandemic failed to keep into account its disparate impact on marginalized communities. Migrant workers were one such marginalized group who were disproportionately impacted by the pandemic. While all of us attending conference webinars may have familiarized ourselves with the peculiarities of working from home, it is a sobering realization that for millions of migrant workers in our country, work from home was never a possibility. In India, the Interstate Migrant Workmen Act was enacted in 1979 to protect the rights of migrant workmen. The law entitled them to equal wages and regular payments, medical facilities and travel allowances, and mandated documentations and registration of workmen to ensure that these rights were in fact secured. This act was given a broader interpretation by the Supreme Court in 1983 in the case of Bandhua Mukta Morcha versus Union of India. In this case, Justice Bhagwati underscored the importance of a workman's right to live life of basic human dignity, to which a migrant worker's right to livelihood is integral. He directed the central government to ensure compliances with social welfare and labor laws enacted to protect this right. Unfortunately, the challenges posed by COVID-19 pandemic have indicated that India's framework for protecting the rights of migrant workers is perhaps inadequate. Stranded far away from their families and their homes, stripped of the sources of income and exposed to fatally dangerous virus, the numerous lockdowns imposed in 2020 threatened the right of life and livelihood of migrant workers like never before. Exceptional times call for exceptional measures, and thus several steps were taken to ease their plight. Shramik trains were organized to give them safe means of going back home. Medical relief camps were set up along the highways to provide shelter, and some states announced a one-time cash transfer for returning migrant workers. The Supreme Court regularly monitored these measures. Directions were issued to simplify and expedite the registration of migrant workers to ensure the last mile transport for workers returning home via trains, to provide free food to the stranded migrants, and above all, to ensure that the numerous measures announced will in fact be implemented in the bona fide interests of migrant workers. High courts across the country stepped in as well by taking cognizance of the specific conditions in their respective states and issuing directions in that regard. The benefits of hindsight allows us to critique our collective response. And I believe that a critique is necessary to ensure that an effective and dynamic response mechanism is in place to address the challenges to the right to life and livelihood of migrant workers. After all, haven't we all heard that the hindsight is 20/20 vision? On a more serious note, we must carefully map the way forward for migrant workers in India. It is nearly trite at this point to advocate for government schemes that guarantee employment, centralized registration of migrant workmen, or even direct credit infusions to aggrieved workmen. However, the devil lies in the details. These well-intentioned suggestions must be accompanied by practical and realistic measures to ensure that the theoretical benefits offered by social welfare laws and government schemes are actually realized. I believe that platforms such as this are crucial in this endeavor. They bring together the best of the legal academia and legal practice to facilitate the exchange of multitude of experience, ideas, insight, resulting in the growth of knowledge on one hand and the constructive critique of state responses to global issues on the other. While I have endeavored to share my views on the 4 themes selected for this session, I keenly look forward to hearing from the panelists that have joined today, which brings the much desired combination of subject matter expertise along with unique international insights. As Nobel laureate and economist Eleanor Ostrom had said, the power of a theory is exactly proportionate to the diversity of the situation it can explain. My heartiest congratulations to the Chandigarh University for organizing this event. I'm certain the wealth of experience of today's speakers will play an important role in fostering a new generation of lawyers with capacity and responsibility to use global lessons and insights to address the real challenges facing the country in particular and the world generally. I would like to be part with the words of ex-American President Barack Obama, which I believe are very much in line with the spirit and intent of this event. For we have always understood that when time changed, so must we, that fidelity to our founding principle requires new responses to new challenges, that preserving our individual freedoms ultimately requires collective action, unquote. Let the world march together because that's the way forward. Thank you.
Thank you so much, my lordship, for your enriching address, whereupon you have touched upon all the themes of the webinar. Thank you so much, my lordship. Now I take the opportunity to invite the co-chair of the technical session, Honorable Judge Professor Dr. Luc Lerisson, President of the Belgian Constitutional Court, President of the European Forum Judges for the Environment, to enlighten us on the topic Nuclear Phase Out in Belgium and Germany, Some Legal Issues. Welcome, my lordship.
Thank you very much for the invitation. I have made a PowerPoint presentation, so I think I can share my screen now. Try it.
Yes, sir, it is there.
Okay. Thank you very much for Chandigarh University. Unfortunately, I cannot visit it this time, but a little bit than a year, 1 year ago, I have been impressed by what has been realized in this short period by Chandigarh University. So in my presentation, I would like to share some information on legal issues which has to do with nuclear phase out, and I would like to illustrate it with two cases, the case of my own country, Belgium, and Germany. First, looking at Belgium, then we see that gradually in the period 1975-1985, nuclear energy has become the main source of electricity production. So we have built 7 nuclear power plants, and we participated in another nuclear power plant shared between France and Belgium, which operated from 67 to 1991. And a little bit more than half of our electricity generation was coming from nuclear energy. Then in 1999, the government at that time, and it was the first time that the Green parties were in government, decided to nuclear phase out because of the safety issues around nuclear energy, and also about concerning the waste, the nuclear waste issue. So, and this decision finally was laid down in an act of parliament of 2013. And here you see the headlines of that act. First point was that no new nuclear power plants are allowed in Belgium. And secondly, the existing ones have in principle to be closed and decommissioned 40 years after they're coming in use. And if you look at the time they came in use, this would happen in the period 2015-2025. And no compensation by the government has to be paid for that phase out. And furthermore, the decommissioning and waste treatment and disposal is at the expense of the private operator, because these power plants are run by private, were run by a private operator. In 2013, there was another government. There was a first amendment of that act. And in that amendment said one of the older plants can be operated for an extra 10 years. So they could produce 10 years more than initially planned. But in that case, the operator has to pay an extra windfall profits tax, because he can produce electricity at a very low cost. And at the same time, some upgrading works are necessary to keep the plants safe. In 2015, again, another government and another amendment. There it was decided that instead of 1, 2 of the older plants can be operated for an extra 10 years period. And this last amendment was challenged before the Constitutional Court and resulted in two judgments of the Constitutional Court. The first one of 2017 and the second one of 2020. The case has been introduced by Inter Environnement Wallonie and Bonbeter Leefmilieu Vlaanderen. These are the two main environmental umbrella organizations in Belgium. So they were challenging the act who was amending the initial act and was allowing to prolong for an extra 10 years two nuclear power plants. So it became from the outset very clear that in this case issues of European Union law were at stake, and these issues had not been solved yet, interpreted yet by the Court of Justice of the European Union. That's why the Constitutional Court referred some questions for a preliminary ruling to the Court of Justice of the European Union. And the Court of Justice of the European Union gave its judgment in July 2019. Then the case came back to the Constitutional Court, and the court annulled the act of 28 June 2015, the amendment, but has deferred the legal effects of it for a period of 3 years to allow the legislator to possibly adopt a new law after, and that's the crucial point, a transboundary environmental impact assessment has been carried out. Because what was the discussion? The discussion was, is it necessary if one decides to prolong the operation of a nuclear power plant for 10 years, is an environmental impact assessment prior to that decision necessary, yes or no? Because Belgium is a small country and the nuclear power plants are very close to the borders of other countries. If that should be a transboundary environmental impact assessment necessary. And the result of resulting from the interpretation given by the Court of Justice of the European Union, it became clear that this was necessary. So the reopening of a nuclear power plant, because meanwhile one of the plants had been provisionally already closed, and the prolongation of another one for 10 years is under European Union law subject to an environmental impact assessment and also a proper assessment of the consequences of that prolongation and restarting on the nature areas. And so as indicated in this case, it should be a transboundary environmental impact assessment. So why the court has given a period of 3 years? Because retroactive annulment, that is the normal way we operate, would jeopardize Belgium's energy supply. There have been some related issues in earlier judgment. The Constitutional Court has been 3 times confronted, this time by demands of annulments of some amending acts introduced by the producers of nuclear power. Why? Because for different years, there has been an increase of the contribution of nuclear operators, of the financial plant operators, to a fund that will decommission is and has to overview the commissioning of nuclear power plants. In these three cases, so and the contribution has been reviewed several times. The court held that there was no discrimination in the way of calculation of this contribution. There was no retroactivity because there was a discussion about this, and there was neither a violation of property rights. And in the second case, there was no violation of European Union law either. So we have three similar cases with similar outcomes from three different annual contributions to that special fund. So these are some of the issues we have been confronted in Belgium concerning this nuclear phase out, which will be on the table the coming years because the actual government has confirmed that we will go for this nuclear phase out. Looking then to Germany, we have seen in the period 1969-1988 an increase of the share of nuclear, decided also to phase out, and all nuclear power plants should gradually close, and all sites finally should be closed in 2020. That was the initial plan. Then in 2010, meanwhile, another government, which has been headed by the actual Chancellor Angela Merkel, it was a conservative government, decided to slow down that closure and give an extra 12 years to finally close down the latest nuclear power plant. But then shortly after, it was already mentioned in 2011, the Fukushima nuclear accident happened, and the government of Mrs. Merkel decided for a 3-month moratorium on the reactor lifespan extension program, which was running, and temporarily also shut down 8 nuclear power plants, the oldest ones, for having reviewed them from a security point of view. And finally, the government reviewed again the nuclear phase-out planning and came to back to the initial plan of the Schröder government. So all nuclear power reactors should be closed by 2020. And there were some legal challenges against this latest decision. And the first one was introduced by Vattenfall. Vattenfall is a Swedish company, but has had shares in 2 nuclear power plants in Germany, and they introduced a claim with the International Center for the Settlement of Investment Disputes in 2002 in Washington. And they are claiming a 4.7 billion euro, which is 5.1 billion US dollar claim for not respecting the originally Merkel plan. One of the questions which are playing a role in that case is what is called the Achmea objection. Achmea is a case which has been decided by the Court of Justice of the European Union, and in this case the Court of Justice held that when it comes to issues governed by European law, one may not submit it to international arbitration. These cases should be settled by the courts, the European courts, and at the end to the Court of Justice of the European Union. So this objection is it's impossible. So this dispute cannot be settled in Washington. But the panel did not follow this objection. This objection has been turned down, and the case is still pending over there. Meanwhile, there were also some challenges in Germany itself. First, the Constitutional Court, Bundesverfassungsgericht, has made meanwhile two decisions. And the first one is from December 2016. And there the Constitutional Court held that the acceleration of the phase out of nuclear energy was unconstitutional because it's not guaranteed that the residual electricity volumes which were allocated to each power plant by the initial law of 2001 on the basis of the big discussions which have taken place at that moment could be almost completely used up for production electricity, and also because adequate compensation was not provided therefore. So the Constitutional Court ordered the government and the parliament to review this act, to amend the act, to look at this compensation issue. The act has been amended, but recently, 12 November 2020, the Constitutional Court judged again that the amended act is still unconstitutional. It held that the compensation for the acceleration of the phasing out, the compensation provided for is insufficient. And the act should be reviewed again. And now, so the discussions are going on in Germany, how to apply this judgment of the Constitutional Courts. And different compensation cases are pending before civil courts in Germany. So this short overview to illustrate that when countries are deciding to go for phase out, difficult legal questions can arise, also constitutional issues. So, and some of them, I think, will be on the table for many more years. So thank you very much for your attention.
Thank you so much, Lordship, for your enlightening presentation. Now I humbly invite Honorable Professor Tracy Hester, University of Houston Law Center, to deliberate on the topic, Dueling Courts, Transnational Enforcement of Environmental Liability. Welcome, sir.
And good morning to everyone. Greetings from Houston, Texas. As always, it's a pleasure to see everyone, and it's an honor to be invited to participate in these amazing conferences that are being held at Chandigarh University. I'm going to immediately perhaps cause a small amount of panic in our conference organizers by going a little bit off script, which is I just wanted to comment on the prior presentation, which was wonderful, and offer a quick side comment on how the United States is wrestling with the same issues. which is namely nuclear power in the United States is not being intentionally phased out by conscious design, but because of increasing cost pressure from cheaper renewable sources, in particular solar, but increasingly wind, a lot of the nuclear power plants, as they're reaching the end of their operational lifespan, are becoming decommissioned. And we're effectively aiming in the same policy direction as some of the directives from Germany that were just described. Part of the increasing pressure on that is because the United States has essentially created a small problem for itself with nuclear waste liability. Under our Nuclear Waste Policy Act, we are supposed to have generated and created a federal high-level nuclear waste depository in Yucca Mountain, which I will show here when I share my screen with everyone. The bottom line, though, is that because of political opposition, that particular facility has never been built. All of our high-level nuclear waste, as a result, is being stored and managed in casks on site at nuclear power plants. So I will just note in passing quickly that the rationality and planning used in the European Union for dealing with nuclear power issues and nuclear waste are admirable, and which would be interesting to compare how the policy implementation in the United States has perhaps yielded slightly different direction. But I'm talking about something else today. Namely, I'd like to talk about how the international commitments for climate change are perhaps being implemented and diluted in unintentional ways by domestic legal systems, and in particular in courts' tort liability judgments. So in the United States, basically the key three things I'd like to talk about with you today is first, the current status of US climate tort judgment activity and how that might be a template for similar activities taking place globally in other national court systems that also have tort causes of action. Number two, I'd like to point out how some of the difficulties in that national tort litigation has led to increasing interest in two other forms of transnational tort litigation. The first of those transnational cases being judgments that are pursued by foreign nationals in domestic courts in the host nation. The second category being judgments pursued by those same plaintiffs, foreign plaintiffs, in their own court system, resulting in a judgment that is sought to be enforced in another nation. So in this case, someone might sue a US subsidiary in another nation in that nation's courts, yield a judgment under tort theories of liability, and then pursue it in enforcement of that judgment in the United States. And each of those three categories of activity are opening up fascinating new doors that may have important implications on how collectively we are going to be wrestling with responding to climate change damages. So let's start with that first basket, namely what's happening in the United States and how is that perhaps a potential benchmark for things that other nations are examining. The most important thing is that the United States is really a tale of two waves of lawsuits. The first wave of lawsuits was brought in the early 2000s through 2011 under federal common law, essentially alleging public nuisance claims, which resulted in substantially important verdicts from three different appellate courts, our 9th, 5th, and 2nd circuits. All of them came to an ignominious end when the US Supreme Court took up one of those cases in a case called Connecticut versus American Electric Power in 2011. And the court unanimously held that federal common law in this particular area no longer existed, because when Congress passed our federal Clean Air Act, it displaced all of that law. All the climate torts vanished overnight. They were all dismissed. All of them had been brought under federal law in federal courts. But the second wave, the one that's causing activity now, has been the same types of laws, claims, tort claims, being filed in state courts as opposed to federal courts, and being filed under state laws, not federal common law. And this has actually proven to be much more energetic and viable than the federal cases. We have over 20 active lawsuits being brought by cities, county governments, and state governments against large corporate energy corporations or chemicals or other greenhouse gas intensive industries, alleging that they share responsibility to pay for costs of damages due to climate change that they contributed to. Those claims have been proceeded to the point where they're on the verge of beginning discovery, substantive motions, and proceeding to trial. Right now, that has resulted in some very intense litigation, which is once again now gone to the U.S. Supreme Court. We are at this point now where we have two different cases pending in the U.S. Supreme Court that have relevance in this area of climate tort claims. So I will just briefly note a little bit what the nature of the claims are. They tend to be nuisance, they tend to be negligence, but increasingly they also include claims of essentially false or misleading or fraudulent communications or statements made by corporations that had a different internal state of knowledge as to the damages caused by climate change and greenhouse gas emissions, as opposed to what they were representing to the public who is buying their products, or to government agencies, which is licensing them. So these claims right now are on the verge of proceeding, in particular in our courts in Maryland, California, and Colorado. As a result, we now have the U.S. Supreme Court has just this week heard oral arguments on a case that is actually on an issue that's a Trojan horse. It's an attempt to clarify the scope of appellate review of a court's decision not to allow removal of the case from a state court to a federal court, which sounds very hyper-technical and very dry. What's really at issue is that the case that's being removed is a climate tort lawsuit. And the Supreme Court is being asked in the United States to take advantage of this narrow procedural issue and essentially take care, proactively resolve the bigger issue of whether or not state law can even apply to climate tort lawsuits, which would essentially foreclose the battlefield before the battle had been engaged. Two of the justices asked about this express issue during oral argument. We will not know whether or not how the court will rule for probably at least 2 or 3 months. But it's interesting to note that only 8 of the justices participated because of the recusal motion, which means effectively we are going to potentially have an even split in the court, which the questioning seemed to be hinting towards. The case I'm talking about is BP versus City of Baltimore, but we have several other courts working up the chain of review as well. So that's what's happening in the United States. We may have either an important Supreme Court case defining the terms for these state law tort lawsuits to proceed, or we may have independent cases proceeding to trial in multiple jurisdictions across the United States, which will open the doors for potential transnational participation by the plaintiffs or companies in those tort claims. So as we're waiting for this other shoe to fall, as we're trying to see how the US courts are going to resolve this fundamental issue, activity is picking up in the other 2 categories I mentioned. Why? Well, because first, bringing these climate tort lawsuits is very difficult. They have enormous procedural challenges, proving standing, proving causation from this particular emission causing this particular climate damage, showing you can get a remedy, showing that the court has the competence under British or US doctrine to be able to issue a decision in this kind of setting. So as a result, even if they proceed to trial, it is going to be enormously challenging for the courts to effectively handle these kinds of cases and redress some of these fundamental jurisdictional issues. So attention's turning to those other 2 categories. The first being foreign plaintiffs bringing their claims directly to the United States. So, and this is the Supreme Court argument. I couldn't resist including the picture. Because of the pandemic, we aren't arguing in front of the Supreme Court. In the Supreme Court, it's all online, just like we are here today. So it's rather a kind of startling image to see the former Solicitor General of the United States standing in front of his home computer, making his oral argument dressed in his suit and tie alone in his living room. But that's where we are this year. So that first category of transnational potential climate tort damages is someone who brings a claim for damages they've incurred in their nation, but they bring it in the other nation where the company is headquartered. In this case, let's assume the United States. These types of direct lawsuits are theoretically possible. There is no barrier to foreign plaintiffs bringing claims in US courts, state or federal. And we've seen judgment attempts like that in multiple settings, including for example, uses of nematicides and pesticides that allegedly injured farmhands in Costa Rica. We've seen other types of allegations of damages due to mining operations in other nations, spills in coastal areas from shipping operations, where the injuries occurred overseas in another nation or another territory, but the claim was brought in the United States. These suffer some of the same hurdles that we just talked about with those US climate tort lawsuits I described. In particular, we still have to show that the court has jurisdiction and standing and proving that they have personal jurisdiction over the defendants. But more importantly, there's issues of a doctrine of forum non-convenience in the United States, and it's applied in other jurisdictions as well, that sometimes, even if the court has jurisdiction, a different court that also has jurisdiction is the more logical site for the lawsuit to take place, because that's where the facts are, that's where the evidence is, that's where the parties are located. And because of forum non-convenience, many of these lawsuits have actually been dismissed in the United States and sent back to the nations where the plaintiffs originally came from for their actions. So we see some of the same types of hurdles popping up in this second category. So where does that leave us then in terms of our third category? And before we move to the third category, I will point, I said there were 2 cases before our US Supreme Court. The second case is Nestle versus Doe, which is an issue where plaintiffs injured due to slave labor in cocoa plantations brought a lawsuit for the injuries they suffered abroad in the United States under the Alien Tort Claims Act. And the United States Supreme Court is deciding whether or not our US Alien Tort Claims Act allows these types of foreign claims against US corporations and individuals in the United States. So we may have 2 major US Supreme Court decisions this year that could set the terms of engagement for future climate tort litigation. But now let's turn to that third category. And this is a similar case in Nigeria, which was filed, that was just issued, decision issued this week from the Hague Court of Appeals, which found that Shell, parent corporation in the Netherlands, was responsible for damages suffered by Nigerian farmers from oil spills, even though the oil spill assets were owned by the subsidiary of Shell in Nigeria. But because the court found that the parent also shared responsibility for preventing those leaks from occurring, they were held liable in this sort of foreign plaintiff being brought in the domestic court model I've talked about. But the third category is the one I think is going to be particularly interesting. And this is the one I think we're going to be seeing some very complex games of chess being played with multiple fora. The idea here is that you can bring an action in another country, render a judgment, and then seek enforcement of it as a foreign judgment in the domestic court of the defendant. So essentially, you sue abroad, collect at home. In the United States, there's actually a specific body of law that governs how you can enforce foreign judgments in this particular kind of context. And it's not statutory. It's actually driven predominantly by federal common law, by a case Hilton v. Guyot that goes back to the late 1800s, 1895. And as a result, that federal common law leaves some of the judgment enforcement to state courts under their respective state laws, which has created some welter of confusion. But the bottom line is that you don't have to reprove your claim. You just have to meet fundamental notions of fairness, competence, that elements of due process and the common expectations of jurisprudential procedure are satisfied. So as a result, you can have a judgment rendered abroad and then enforce it relatively straightforwardly when you bring it to a foreign jurisdiction. So as a result, we've seen some of these skirmishes happening, not with a climate tort yet, but with other environmental contamination cases. There's a very high profile, notorious case in the United States where a group of Ecuadorian plaintiffs brought claims against Chevron, initially in the United States, claiming that they'd been injured by oil contamination in the Amazonian jungle in the 1950s and 1960s. That lawsuit in the United States was dismissed for forum nonconvenience and sent back to Ecuador. But the trial proceeded under Ecuadorian law in an Ecuadorian court and yielded an $8.65 billion judgment. Now that judgment then was sought to be enforced in the United States. And the United States court that heard it rejected the claim, arguing that it was a corrupt decision. And it has led to a cascade of follow-up enforcement actions in Canada, Brazil, Argentina, even in Gibraltar, which have attempted to expand the scope and basically take that Ecuadorian judgment and just turn it into liquid damages. Stay tuned. Those judgment efforts have not been successful so far, but nonetheless, they show the way. We may have a situation in the future, and we're seeing it now with some Canadian mining company judgments, which I've described at the bottom of this slide, where a similar type of judgment rendered abroad that is sought to be enforced at home will not suffer the same allegations of fraud or corruption, but will just be a large verdict issued under domestic law. And we are going to be seeing a real acid test of how these federal common law issues apply, particularly in climate litigation that's transnational, which we're already seeing. Here is a very high profile case that's being filed by a Peruvian tour guide and farmer who is seeking justice in the German courts. So where is this likely to lead us then? Bottom line, we're going to see more suits like this, both in domestic courts, not only in the United States, but other nations will see climate tort actions just straight up seeking to force policy forward by assigning liability to the actors who are generating the most greenhouse gases. But those strictly domestic actions will be run in parallel to foreign judgments, either being brought by foreign plaintiffs in the domestic courts or by foreign plaintiffs in their own courts, getting their own judgments and then seeking to enforce them in the United States. We're going to have to rethink those principles we use for enforcement of foreign judgments from the perspective of what fundamental human rights need to be respected, what procedural due process principles must be maintained, and how do we make sure that all of those principles combined still lead us to the climate protection steps and emission reductions we need to have. So we're not going to see a climate liability treaty or convention. We're likely to see increasing activity with these court decisions, and we're going to be seeing some effort at some point to systematize and think through the best framework on how to harmonize what could be a very broad and disparate collection of climate tort liability judgments. With that, I hope I've given everyone a good amount of food for thought, and I look forward to discussing with everyone and at the end of the panel. Thank you.
Thank you so much, sir, for your pearls of wisdom. Now I take the opportunity to humbly invite Honorable Professor Dr. Gitanjali Nayan Gill, Professor of Environmental Law, Northumbria Law School, to deliver her address on the topic Transformative Sustainability, SDGs located within COVID-19. Ma'am, welcome, please.
Thank you very much. And well, the topic which I sent was basically 2 days back was reimagining environmental law education in post-COVID times. So the thematic area which I'm going to be taking is in relation to the right to education. But before I start off, I take this opportunity to thank Chandigarh University and in particular, Honorable Justice Vatantra Kumar for organizing this brilliant seminar at this critical juncture. Thank you so much for giving me an opportunity to share my views. The title of the conference, Global Challenges in Modern Times, is of immense importance, particularly as the world is struggling with the challenging times of COVID. There is nothing more global than the environment. Climate change, biodiversity, pollution, land-related issues, wetlands, food security, water, sanitation, all these issues have become so important and And the importance can only be judged by as what we are going through, these COVID crises. Yesterday and today morning, these are very interesting sessions. And yesterday, Justice Surikant, when he started the conference, he started with a sentence by saying, education is a human right. And accordingly, he posed 3 questions before us. The first one being, what is the aim of education? The second one being, the tort of education. And the third one being, the content of education. Alongside Justice Surikant, the other distinguished speakers brought in a string of thematic issues which were binding with one another. And there were terms like consciousness, vulnerabilities, human rights, climate change, human rights both in the conceptual part as well as in the normative part, environmental constitutionalism, judiciary's role. All these issues were being deliberated. The spectre of COVID has influenced this international seminar. And there was a question which was asked in both the sessions yesterday, that whether there appears to be a silver lining in these post-COVID times. And it is here that I start my presentation by saying, the answer is yes. A crisis offers an opportunity, a progressive opportunity to question and change the thinking and the relationship with the people and with the planet. And in this regard, I have 3 reasons to think about this as an opportunity. The first one being, the seismic virus has disproportionately affected the underprivileged, the vulnerables, and the marginalized. Number 2, there is an ongoing debate about what is it that we want? Is it the question of needs or is it the question of wants? And number 3, the issue of implementing a global green agenda, which is based upon sustainable production and sustainable consumption. Now, these are issues that really make us think where we stand. Shouldn't we take this COVID as an opportunity to broaden our thinking, broaden our horizon in trying to find an opportunity to build upon how this education might play a very important role? And it is in this context I present today some of my views in relation to how this right to education will look into post-COVID times, particularly focusing from environmental law education point of view. The thematic area of education is very relevant to India, essentially because India is embarking upon a new education policy. Prime Minister Modi in 2020 tweeted, and I put it in quotes, the new education policy has got 5 pillars: access, equity, quality, affordability, and accountability. This new education policy is an end-to-end educational roadmap for India. And in the sector of higher education, research incentive institutions and highly teaching incentive institutions are the need that India should look for. Rather than rote for study or rote for learning and learning for exams, there should be imaginative and flexible curricula creative combination of disciplines for study, unquote. Consequently, there is a need that we start looking for a new opportunity. And this is an opportunity which COVID has given us because we need to revisit the environmental law education, and we need to see how this environmental law education would look into post-COVID times. The traditional method of environmental law education is primarily statutory law and case law. And what it does is, it develops our basic skill sets. This is not to say, let me be very clear, that this is not a good methodology. I'm not saying that. But I'm going one step ahead to say that now is the time to revisit and think about what sort of legal education do we need now? And the reason being is that environmental matters and environmental disputes and often...
Ma'am, kindly unmute yourself. You're not audible.
Can you hear me now?
Yes, ma'am. Yes,
Yeah.
ma'am.
Yeah.
Thank you so much.
So the point which I was making was that this basic skill set which we have in the form of statutory law and case law is not adequate enough to prepare us for environmental law education. Because environmental disputes, as I said, are polycentric, complex, multidisciplinary, and often political. And consequently, what we need is a development of holistic skill sets that transcend the boundaries of black letter law approach. And it is here that I propose 4 points that are forward-looking, that have a forward-looking agenda. And this is a work in progress, but these 4 are not the finishing points. But from here, there are different elements that can come into existence. The first point which I make is that this environmental law education should have the foundational issues that should include the issues of justice, equity, equality, human rights, globalization, consumption patterns, production patterns, and because these are the issues which provide us with a transformative agenda. So if we are looking into a post-COVID environmental law education, the pitch has to be for a transformative agenda that underpins the Sustainable Development Goals framework. When we are talking of Sustainable Development Goals, there are 17 in number, which have 3 cross-secting issues that impact on the lives of each and every person. Prominently being social inclusion, environmental protection, and economic development. The 2030 Sustainable Development Goals framework heals and secures our planet and shifts the world on a sustainable and a resilient path. In fact, the present development is that now the reports have started coming that we have to think beyond 2030, and now the reports are focusing on what our lives should be or how our planet should be in 2050. But keeping a closer eye, I think the environmental law education must look into a transformative agenda that fits into or that underpins the Sustainable Development Goals framework. The Sustainable Development Goals have got 5 P's: people, planet, prosperity, peace, and partnership. And it is here that Sustainable Development Goal 4 becomes very important, because Goal 4 is talking about promoting quality education. And therefore, the point which I'm trying to make here is that environmental law education has to be transformative in nature. And when I use the word transformative, it basically means a solution-oriented approach that responds to societal changes driven by multiple forms of knowledge. It involves active construction of new practices, for example, redesigning or developing new curricula with new meanings attached to it. By adopting a transformative approach in environmental law education, the focus is more on sustainable and equitable futures, which we are looking out for, which can be approached both from a normative point of view, that is, what is good and what is desirable, as well as from an analytical point of view that goes into the question of what, how, and why. For example, environmental injustices or environmental racism that we keep on talking about. So we start questioning what is this, how it is, and why it is. So these questions in environmental law education become very important when we are talking about the transformative agenda to be adopted. The second point which I talk is in relation to the research methodology. How should the research look in terms of the future? And here I would say that the research has to be original with reach, significance, and rigor. Research needs to be high quality and that is what is central in redesigning the environmental law education. Descriptive research has got no added value to knowledge, understanding, and critical analysis. Therefore, research in higher education institutions must have an experiential approach that applies knowledge, theory to the real world to solve the problem. And that is where the transformative agenda comes into picture. What is important in this experiential research is you need to work with the stakeholders. Who are your stakeholders in this regard? The stakeholders could be the top down or the bottom up. So we are looking into doing research with either the policymakers, the judges, the institutions that are responsible for environmental protection, or even our civil society, the NGOs. So the knowledge that comes up in this regard becomes very important to deal with those matters. There should be this kind of experiential learning always has the element of accommodating different kind of views. We cannot be trying to say that the research which comes out from legal side is enough in relation to provide solutions to the global challenges. And therefore, it's important that this research accommodates the views of each and every person. And that is why the generation of empirical data, the questions of social reality, the interdisciplinary nature of research, social engagement, collaborative engagement socio-legal research become very important. Identifying the problem, finding a solution to the problem is the transformative agenda that should be taken into account for environmental law education. And because this will fit into the implementation of the Sustainable Development Goals agenda. Another point which I would like to make is that this research has to be very much interdisciplinary in its nature. And when we talk about the interdisciplinary aspect of it, it means it should not be confined only to law. Because when we become very much inward, we cannot find solutions to the problem. So therefore, this interdisciplinary research must be looking into integration of concepts and methods between the disciplines. The environmental law education that we talk about should draw from other disciplines rather than having a very narrow legal approach. And here I advance the argument of interactional expertise. That is the interactional expertise between different disciplines. This interactional expertise speaks the languages of all disciplines, and that is what is important to be expressed in environmental matters. For example, we have the principle known as, and it's been applied throughout in cases, that is the precautionary principle. But simultaneously, we also have the concept of scientific certainty or uncertainty and the associated risks that are involved with it. How do we merge this in the language of science and law is very important. Therefore, it's important that whenever we talk of environmental matters and we try to look into the curriculum that needs to be developed, the interdisciplinarity is very important in this regard. Yes, I do understand, and I do take the point that environmental challenges can be, interdisciplinary research can be very, very challenging because there are institutional, cultural, and knowledge-based barriers. But post-COVID, we have to cross these barriers and we have to move on to a transformative agenda that feeds into the Sustainable Development Goals paradigm. And that is why I say we cannot be inward looking. We should not be prisoners of our own discipline. There is a need that we should appreciate the others. So the others, when it comes, it could be from pure sciences, from social sciences, from economics, political science, business management, business association, because sustainable development goals are ultimately providing you the foundations on which the future we want rests. And that is where all these issues become important. And the last point I would like to make is the role of judiciary. As an institution and as an enabler to bring a transformative change, particularly under Goal 16 of the Sustainable Development Goals, the role of courts is crucial. And this becomes very important in environmental law education because the courts can ensure that environmental rule of law or the basic aspects of rule of law are maintained. It's very relevant for India because in 1991, in the case of MC Mehta versus Union of India, the Supreme Court ordered that environment as a discipline should be a compulsory subject not only at the school level, but at the university level. It is now at the time for the judiciary to be the progressive nudgers. And I use the term progressive nudgers because the importance and the implementation of sustainable development goals must be expressed loudly and directly. There have been many commendable judgments coming from the Indian judiciary over the recent years. And I take this opportunity to congratulate Honorable Justice Swatantra Kumar. And I've always said the phase from 2012 to 2017 was a golden era in the National Green Tribunal. Commendable judgments came, which touched on so many issues that were passed by the courts, whether the Supreme Court or the NGT. For example, look at the air pollution case, the food security case, the water, the wildlife, poverty reduction. All these cases came out with a transformative agenda, a transformative space wherein the concepts like transformative constitutionalism, ecocentrism, environmental rule of law, human rights discourse were being introduced. And they were being wrapped around the concept of the right to life. The Indian judiciary and judiciary all over the world is not revolutionary, but then they can act as progressive nudgers. And they can be progressive nudgers towards a transformative agenda. Because what they are doing is they are incrementally and deliberately creating a space to bring about a change in that regard. And if I look into it, yesterday I searched something, there are only 3 cases which have come out in India where they are specifically talking about sustainable development goals. One case comes from the Supreme Court of India in 2019 in Hanuman Lakshman's case, and 2 cases have come from NGT in 2020. So the point or the pitch which I'm making is the language of SDGs needs to be more spoken, more frequently, publicly, and convincingly. The judicial voice provides us with legitimacy, builds public confidence, and public trust. If the language of SDGs, Sustainable Development Goals, gets reflected into the judgments, definitely it will resonate throughout the environmental law curriculum or environmental law education. In the conclusion, I would like to say, COVID-19 has exposed the vulnerabilities of our fractured societies, being ill-prepared or underprepared. It is now time to think about how, not only about our lifestyles, not only about the production or consumption matter, but also to think about our education, the future for all, where our education should go. And putting acronyms to this education, I think the following can provide us with a pathway. E should stand for equality and equity. D stands for dedication. U stands for understanding. C for caring. A for awareness. T for togetherness. I for inclusiveness. O for organization. And N for nurturing. International seminars, like what has been organized by Chandigarh University, gives the space, creates a discursive space to engage into dialogues so that a change can be brought about. Because this change is very important in order to not only meet the present challenges, but also to meet the future ones. And the choices are in our hands in relation to the future we are looking out for. Thank you very much. Thank you.
Thank you so much, ma'am, for your wonderful overview of the topic. Thank you so much. Now I humbly invite Honorable Mr. Justice Priya Sadde, Sri Lankan judge and lawyer who was the 45th Chief Justice of Sri Lanka and a former Solicitor General of Sri Lanka, to deliver his speech on the topic International Conventions on Human Rights. Welcome, my lordship.
Can you hear me?
Yes, sir. Yes, sir, you're audible. Yes.
Good morning. First of all, I am thankful to Justice Swatantra Kumar and Chandigarh University for inviting me for this webinar. And in fact, I am very pleased to accept the invitation. I have decided to speak on the topic International Human Rights Conventions, and the question there was whether the domestic laws diluted its essence. First of all, I must briefly refer to the relevant conventions and covenants. Of course, the UN Charter is the basis for everything. And other than UN Charter, there are three important instruments. One is the Universal Declaration of Human Rights. The next one is the International Covenant on Civil and Political Rights. And third one is the International Covenant on Economic and Social Rights. First one, Universal Declaration of Human Rights is only a declaration and a non-binding instrument. Whereas other two, International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights, they are binding documents. Actually, they are considered as the foundation or the basis of the human rights law regime. And apart from that, there are so many other conventions and covenants. One is Convention on Prevention and Punishment of Crime of Genocide, then Convention Against Torture, then Convention on Elimination of all forms of what you call that, racial discrimination, then elimination of all forms of discrimination of women. Then we have Convention on Rights of Child. Then we have conventions concerning refugees, then migratory workers. Likewise, there are so many conventions. But in most of the conventions, the state parties have agreed and ratified. So what is the purpose of entering into agreements and ratifying it? One thing, when a state party enters into an agreement, it should do so in good faith. So bona fide is an essential factor. And secondly, it must take all steps to comply with or give force to the agreement. So that is called pacta sunt servanda. So agreements are meant to be complied. So the bona fide, the good faith, and the compliance, those are the essential factors regarding all international agreement, not only pertaining to human rights. Then the second question is whether ratification alone will give force to this agreement, because we have two manners of giving effect to international instrument. One is the certain governments follow what is called the monist system. So when agreement is ratified, it will automatically becomes part of the domestic laws. But those countries are few in number. But majority of the countries follow dualistic approach. That means to give effect to the agreement, they must pass enabling legislation. Either they must incorporate that in the constitution or other laws. So unless that is done, the agreements are of no force in the domestic level. So those are the essential things parties should follow. And then the question is, the various countries have different approaches towards human rights. Certain human rights, such as civil and political rights, are given preference by the countries which cherished individual freedoms, individual rights. Certain other countries will consider economic, social, and cultural rights are important factors. So it depends on the political ideology, form of government, and cultural and other various aspects. But nevertheless, we have to find out the crux of this international agreement. When we examine the UN Charter or the Universal Declaration of Human Rights, the basis is the recognition of the inherent dignity and equal and inalienable rights of the individuals. If I may permit it, I will refer to the certain preamble of Universal Declaration of Human Rights. It states, whereas recognition of inherent dignity and of equal and inalienable rights of all members of human family is the foundation of freedom, justice, and peace in the world. So that is the basic thing. And it proceeds further stating, whereas it is essential if a man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. So the rule of law is very important in the protection of human rights. What is rule of law? Of course, we all know that it's the supremacy of the law. But apart from that, there are other aspects too. There should be an independent judiciary, then respect for democratic institutions and good governance and other things. So without rule of law,
किसान को कमजोर होने की जरूरत नहीं है। षड्यंत्र था, वो षड्यंत्र से किसान निकल चुका है। वो एक षड्यंत्र था, किसानों का मनोबल डाउन करने का षड्यंत्र था। किसानों का मनोबल कम नहीं होगा, किसान मजबूती के साथ में लड़ेगा।
Equal and inalienable rights of individuals or the family. And so the individual rights takes a very important role. And also the Article 1 refers to all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. So the question is, refers to people born free. So they are also saying, I think during the French Revolution, I think one leader referred, I don't know whether it is Rousseau or Voltaire, he said, man is born free, yet he is in chains. So in the French Revolution, the main slogan was liberty, equality, and fraternity. So the liberty takes a very important role. And other one is the equality. Equality is also very important because recognition of equal rights and equal protection of law. And also linked to that, there is a non-discriminatory aspect. The rights should be enjoyed by every person without any distinction regarding race, color, language, religion, political or national law, the origin, then sex, birth, and other rights. So without any distinction, it should be enjoyed by individuals. So equality is also a main aspect. Then the other aspect is the state parties must provide an adequate remedy for the protection and enforcement of human rights. Those are necessary factors to further the human rights. Then the next aspect is regarding the declaration of public emergency, because the convention itself provides for the curtailment or abridgment of rights during an emergency in the interest of national security or public order, national economy, moral, and also health. On those grounds, rights could be curtailed, but the extent of curtailment should be decided and depend on the situation. So, but there are other rights, basic rights, which should not be abridged or curtailed. So one is right to life and this liberty and security of person. Another one is no person shall be subject to cruel, inhuman, and degrading treatment or punishment. Then third one is freedom from slavery or servitude. Then other one is freedom of thought, conscience, and religion. And fourth one, another one is each person has a right to a personality. That right should be recognized by state. Then there's another rule that against retrospective or ex post facto legislation. So no one can be punished for an act or an omission which is not an offense at the time of committing the act or omission. So that is also ruled against retrospective legislation. Those are the things which should not be abridged or curtailed even during the time of emergency. Then we have other rights like protection from arbitrary arrest and detention. Then presumption of innocence. That means a person is presumed innocent until he is proved. And fair trial by any competent court adopting proper procedure. And likewise, there are certain rights pertaining to the individual. Then, of course, we have the other rights like freedom of expression, then freedom of association, freedom of assembly, then freedom of religion, of course, it's regarded as a main one, falling under the earlier category. So that means freedom of conscious belief and religion. Then we have, other than that, like this right to employment, and then right to develop one's culture. Those are the main rights. Then apart from that, we have economic and social and economic cultural rights, like right to education, right to health, then right to enjoy your culture and promote it. Then regarding the family, about the recognition of a family, marriage, and rights of children. Those are also included as fundamental rights. So those rights please bear with me.
So my humble submission, whether it's complete
Then one is, I'm extremely sorry. Then next one is the approach of state parties regarding fundamental rights. There are certain states, they incorporated that in the constitution. Constitution itself guarantees fundamental rights. So it is raised to this upper echelon of the status of constitutional rights. Then there are other parties who incorporate that in normal statutes, normal laws. Then there are third category where there is no incorporation, but when passing legislation, they follow the norms. They use fundamental rights when enacting laws. So there are three categories which they're regarding the approaches by various state parties. Then the next question is about remedies. As I said, there are hierarchical rights and also the remedies. Remedies means you must provide that when there is an infringement, there should be a remedy to punish the offenders. So the remedies are just given by the various constitutions, and in fact, especially in India, Pakistan, and Sri Lanka, those rights are incorporated in the constitution itself, and the individual affected party can petition the Supreme Court for relief, and Supreme Court can inquire into that and grant relief. So there is the method adopted by countries like India, Pakistan, Sri Lanka, by incorporating the fundamental rights in the constitution and giving.
Sir, kindly unmute yourself. You're not audible.
I'm
yes,
sorry.
It's okay. It's okay. It's audible now.
Okay now.
Yes, yes. So you are audible.
Shall I repeat it or?
No, sir. It's perfectly fine.
Perfectly fine. So the Supreme Court in India Sri Lanka and Pakistan, judges have played a proactive role, and their judiciary was, in fact, a vibrant judiciary, and they expand the canvas of the fundamental rights jurisdiction and allow this expanded the locus standi, even permitting this interested group various groups can represent the rights of the affected party, and also public trust doctrine. Those things are adopted by the Supreme Court to give relief to the affected parties. Then, of course, it expanded the scope also by including certain rights as fundamental rights. We all know that all fundamental rights are not given the same status. Some are justiciable, others are not. Others form part of the directive principles or guidelines like right to health, right to education. Likewise, they are considered as not enforceable rights because most of those rights cannot be absolute rights because it depends on the resources available to a country. So it has to do what it can do at the highest level, what can be attained. So they have not reached the standard of certain other rights. But those rights are also considered by Supreme Court, like right to environment, clean environment, so that try to link to right to life. Like even the education, those things are included. Likewise, the various countries have adopted, especially the judiciary, adopted various methods to further and promote the private fundamental rights by giving or providing effective remedies. Then next one is about the attitudes of states. So it all depends on the ideology, form of government, or religious or cultural background. If you take the case of USA, I believe it ratified the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights in 1992. And also it provided with so many reservations and declarations. And also the question of the UN, I believe, what they say is the Constitution and its amendments are the important things to enforce human rights. So they apply the American Constitution and amendments, especially due process and other things, to safeguard and promote fundamental rights. Then there are other countries, as I said earlier, China, Russia, they believe that this enforcement of fundamental rights is not a matter for the international community, it's a matter for domestic courts and for the countries concerned. So they adopt that attitude. Then again, another group which neither incorporated fundamental rights in the statutes, but they use that as a guideline in legislative and administrative acts. So likewise, they comply. Then the next question is COVID.
May I request His Lordship, please, the other panelists have to leave. We will
only 2 minutes means COVID pandemic, but that imposed so many restrictions on health grounds. One of course, freedom of movement and freedom of association, and also regarding the family union. And that also under right to health, the government can, in times of, government is required to control pandemics and other diseases. So it is part of the health, on health ground, it has. So I don't want, because of the time restraint, I don't want to take, speak further, and I must thank all of you all. Thank you for kind attention. Thank you.
Thank you so much, Lordship, for sharing your valuable knowledge. I'm really thankful to Honorable Excellencies, luminaries, and panelists of the day for their enlightening presentations, which had kept us all to pay our undivided attention towards every word uttered by them. I'm fortunately endowed with the task to summarize today's wonderful session. The session was initiated by Honorable Mr. Justice Satantra Kumarji with his great welcome address, followed by the address of Honorable Pro-Chancellor, Professor Dr. R.S. Baba, Chandigarh University. The torch of wisdom was further carried by Honorable Mr. Justice Sanjay Kishan Paul, Judge Supreme Court of India. Lordship, in his articulated speech, has very rightly touched upon the topics of webinar. He has specifically pointed out that education is a subject matter of concern and right to education policies needs constant changes. Court decisions in socio-legal matters can lead to full enjoyment of rights. We all need to ponder upon the environmental issues, and there is a need to have collaborative efforts of all of us to enjoy the gifts of nature. Nuclear materials should be used for peaceful purposes and not for destruction. Thereafter, we got the opportunity to have amongst us Honorable Judge Dr. L. Larison, who has avertedly pointed out specifically upon two cases, one in Belgium and Germany, in relation to the nuclear phase out there, wherein amendments were done in the acts in 2017, 2019, 2020. He has discussed the decisions of the courts with us, and in relation to Germany, there was an increase in nuclear power plants in 1969 and 1988. Then we had amongst us Honorable Professor Tracy Hester from University of Houston Law Center, who has thrown light on global environmental challenges, status of federal and state common law tort liability, limits on foreign plaintiffs seeking relief by transnational claims in US courts. He has further elaborated the waves of lawsuits in relation to environment, etc., and the relief sought in the same in the US courts. The next panelist of the day was Honorable Professor Dr. Gitanjali Nain Gill, Professor of Environmental Law, Northumbria Law School, who has spoken on climate changes, food security, etc. According to her, crisis offers a progressive opportunity, and there is an online going on debate where in relation to question of need and question of wants. She had specifically talked about that there is a need to have research which should be experiential, and we should start looking upon our planet, what it should be in the next coming years, like in 2030. Moving further, we had with us Honorable Mr. Justice Priya Sadde, Sri Lankan judge and lawyer, who has enlightened us and elaborated about the international conventions in relation to human rights, International Covenant on Economic and Social Rights, International Covenant on Civil and Political Rights, and he has also discussed with us in relation to other convention in relation to elimination of all forms of racial discrimination, in relation to women, migrants, etc. The session was overall very holistic and enriching, and I congratulate all of us to be part of such an ocean of knowledge. My Lordship, Honorable Mr. Justice Sutanta Kumarji, I seek your permission for the question answer session.
Kindly go ahead, please.
Thank you, my Lordship. The first question is from Ms. Nidhi, who is a student.
Good morning to all the esteemed dignitaries. My name is Nidhi and I'm a law student. It's a matter of absolute pleasure and honor for me to be able to be part of such distinct and informative line of thoughts. My question is addressed to Your Lordship, Honorable Justice, Mr. Sanjay Kishan Paul. Your Lordship, it's said that even if all safety precautions are followed, there's no assurance that a nuclear power plant accident will not occur. It's not a hidden fact that if a nuclear power plant accident occurs, the environment and surrounding people could be subjected to alarming levels of radiation. The unfortunate incident in 2011 at the nuclear power plant in Fukushima, Japan, is one of the worst hit nuclear disasters in history. So my question is it really beneficial to move towards nuclear power plant for countries like India?
Can you hear me? Am I audible?
Yes, absolutely.
Yes, this
is the subject which I touched even in my opening remarks, where I mentioned the fact that the debate over whether we should go to the methods of generation of energy which are non-nuclear has been engaging attention, and the movement is there. Now, you saw the lecture also, what is happening in Europe, in Germany, in Belgium. So I think certainly a movement towards a non-nuclear based energy plants is something which is uniformly accepted. I don't think there's an issue in it. There is, of course, another aspect of the defense utilizations, over which there will always be some debate and controversy, or as the professor spoke about the US, because of the price factoring in it. So this is a balancing which each country will have to do, and maybe the precaution required for keeping these plants and the possibility of a problem always weighs in favor of energy derived from either sources like the sun and the wind.
Thank you, sir.
Lordship. The next question is from Dr. Radhika Dev Verma, Faculty of Law.
Good afternoon, Your Excellencies and distinguished dignitaries. Thank you very much for enriching us with your knowledge. As Honorable Professor Dr. Gitanjali Nayan Gill has wonderfully explained about transformative agenda for 2050, I wish to seek Honorable Ma'am's opinion on the goal 16 of improving the environmental rule of law, access to justice and environmental dispute resolution, essential for achieving the UN's 2030 Agenda for Sustainable Development Goals. To accomplish this goal, although more than 1,200 specialized courts and tribunals dealing exclusively with environmental matters are functioning worldwide. In India, as per the Ministry of Environment, Forest and Climate Change Report 2018, there are 110 cases pending in the Supreme Court and 3,573 cases are pending under NGT. Ma'am, in your opinion, how is the judiciary working behind the scenes to fast track these cases to achieve 2030 agenda?
Thank you so much. Well, I think we should take pride in the fact that India became the first country or developing country to establish the National Green Tribunal. And as I said, I mean, the last 10 years of my life have been devoted to the National Green Tribunal, but now I'm moving towards another development agenda, which is very different. I think there are challenges in our country because population is another challenge, and we are a very litigious kind of a society. But having said that, there is all effort which is being made in order to reduce this litigation. I mean, statistically, if you look into it, and if you go on the NGT website, it clearly shows that they have actually decided about 90% of the cases which are already there. But the question is it the speed which is important? I understand the speed is very important. But what about the quality of justice that we are talking about? And I think that is where we need to tease out the issues. It should not be a case of talking about, okay, this is the time frame we have to, because statutorily NGT Act talks about that, but that should not be at the cost of justice. People should be given adequate responses or opportunities to have access to these kind of mechanisms. Yes, NGT is a very good development. And I think time has come now that this sort of a development, which started off from 2011, then moved under the aegis of Justice Swatantra Kumar, and now the present chairman, we need to build that momentum. That's very important because Goal 16 talks about peaceful institutions, transparent institutions, accountable institutions. And I think time is there now, we have to revisit. And I somewhere, in November, there was a webinar, I said, 10 years of NGT has gone by. Now is the time for NGT to revisit its working. I think that's the point which Honorable Justice Cole has taken up by saying, developing a critique in our own working systems. And I think that's very important when we look into the aspects of access to justice.
Thank you, ma'am.
Thank you so much, ma'am. Moving further with the next question, it is from Mr. Niket, who is one of the law students. Niket, please.
Good afternoon to all the dignitaries. My question is addressed to Honorable Professor Tracy Hester, as he mentioned waste management at the nuclear plants. Professor, even though nuclear energy is the future, but more than 250,000 metric tons of highly radioactive waste sits in storage near nuclear plants and weapon production facilities worldwide, with over 90,000 metric tons in the US alone. The radiations being emitted from the same can pose serious risks to human health and the environment. So, Professor, in your opinion, how can the judiciary facilitate the waste management from these nuclear plants?
It's going to be difficult. Probably the approach that's being tried now is premised on the idea that we're not going to reach a political resolution with our federal government. Our problem is that the current statute, which is the 1982 Nuclear Waste Policy Act, assumes that the federal government will create a centralized nuclear waste repository at Yucca Mountain. Politically, that just has not happened, and it does not appear it's going to happen. So we're essentially in gridlock. To break that gridlock, what we're seeing is that state governments are trying to take steps to pressure the federal government by increasing liability. For example, New York, just last month, passed a new law which basically is going to increase taxes on property being used to store nuclear waste. It's solely a device to try and increase the political pressure on the federal government to do something by essentially using the tax authority of the states to raise the price tag effectively. So the judiciary obviously will play a key role in that process. They're working within a state framework. At the end of the day, the physics are clear. We need to have a safe geologic storage facility. But the politics right now are going to be, as you know, in the United States, we're having a little bit of intractable politic issues at the moment. I suspect this one will probably will continue to drag on for at least another 5 to 10 years.
Okay, thank you, Professor.
Thank you so much, sir. The next question is from Dr. Harshita Thalwal, Law Faculty.
Very good afternoon to all the dignitaries present here. I feel honored to be the part of this webinar, which is graced by esteemed judges of Supreme Court of India and luminaries across the globe. My query is relating to migration, and it is addressed to Honorable Justice Priyasad Dev. Sir, as you were talking about the various international conventions relating to human rights, one of the convention was UN Convention on Migrants' Right. So my question is that as we know that migration is a global challenge, it is a global problem for the host country. In that we are talking about granting of right to livelihood. So in the light of this particular thing, don't you think that granting of right to livelihood will only perpetuate the problem?
Can you hear me?
Yes, sir.
Yes, sir. Sir, you're not audible. You're not audible, sir. Kindly unmute yourself. My lordship, please kindly unmute yourself. You're not audible.
Now, as regards to migrants, there are two types of migrants. One are legally migrating, and there's another group, illegal migrants, and they are committing offenses like border violations, and also some are victims of human trafficking. So for them, it's very difficult to provide livelihood and other things, because when they enter, they don't have valid documents. So they are at the mercy of various intermediaries who take over their passports and exploit them. so they can't have recourse to any country. As far as the other workers who migrate in a formal manner, then actually not only this country of origin, they also have some sort of a responsibility, but the other countries who employed, they also have to provide for basic salaries and other facilities. So only unfortunately, they can't bargain. So they are at the mercy of employers, and there's no mechanism to enforce that. But International Organization of Migrants are looking after the other these people who are subject to exploitation by various people who are mostly illegal migrants who are migrating in search of jobs and other things, basically economic migrants. And also there are some category of political victims also running away from persecution. So there are two categories, but unfortunately there's no proper mechanism to implement their rights. So the countries must get together, but in Sri Lanka, of course, there's a Sri Lankan Foreign Exchange Bureau, and they coordinate. And in this consular level, they look after them. But as far as the contracts are concerned, it's a matter for the host country, depending on their contractual laws. I believe that satisfies your question.
Yes, sir. Thank you so much, sir.
Thank you so much, my lordship. Moving further, the next question is from one of the students, Mr. Shrikant Bhutani.
Very good morning to all the dignitaries present. It has been an absolute honor to listen to you for the past hour and a half. My question is directed at Honorable Professor Mr. Lavison. Your Excellency, we've seen issues like corruption, price rises, and unemployment being highlighted during elections. Why isn't environment seen as a vital issue in political party manifestos when the situation is very worse?
Sorry, I didn't understand the question, so maybe can you, because the sound is not so good.
Sure, no problem, Your Excellency. I'll repeat the question one more time. We have seen issues like corruption, price rises, and unemployment being highlighted during elections. Why isn't environment seen as a vital issue in political party manifestos when the situation is very worse?
Yeah, the same, still the same problem of understand. Maybe can you repeat the question?
Maybe, sir, I intervene. Sorry, I intervene it, sir. Justice Leveson, the student is Shrikant is saying it that why environment issue is not kept as a mandate of political parties, whereas for unemployment, for food and for jobs, for other issues they are there. Why not environment is kept as a matter of concern during the campaigning in election mandate by political parties?
Luke, he wants to know from you why environment doesn't get its proper priority.
Yes, it's. I think it's seen by part of the general public as not a pressing issue, and of course political parties try to reach as much to the priorities the people have, but maybe there is a change in that, even globally. I think earlier this week there was a report from the United Nations Development Program in which a global survey of people's public opinion was done, and then you see, for example, that climate change is worldwide seen for a lot of people, the majority of the people, as a pressing issue. So I think as soon as this is seen and by political parties, that will come higher on the agenda. So look to the recent elections in the United States. I think the Green Deal agenda from the Biden campaign played an important role. Looking at the European Union, we have now the European Commission, where the European Green Deal is a top priority. So it can change, I think, and certainly if we have to restore our economies after when the pandemic is over, then it will be necessary to do it in a sustainable way, and that's why I think these green policies are very important. And I'm confident that in different parts of the world, including now recently in the US, but also in the European Union, that will be very important. So things can change over time, I think.
Thank you so much.
Thank you so much, my lordship. We end up with the question answer session. Now I very humbly invite Mr. Deepinder Singh, Program Head International Relations, Chandigarh University, to extend the vote of thanks. Welcome, sir.
Thank you so much. Good afternoon, everyone. This is Deepinder Sandhu, Program Head International Relations. And on behalf of Chandigarh University, I would like to express a vote of thanks to thank all the distinguished guests and speakers present here with us today, who have been part of this one-of-its-kind webinar on the theme Global Challenges in Modern Times. I would like to take this moment to thank the distinguished judge of the Honorable Supreme Court of India, Honorable Mr. Justice Sanjay Kishan Kaul, for being the chair, and Honorable Judge Professor Dr. Lavison, President of the Belgian Constitutional Court, President of the European Forum Judges for the Environment, for being the co-chair of this conference. I also thank Honorable Mr. Justice Vatantra Kumar, former Judge, Supreme Court of India, and former Chairman, National Green Tribunal, New Delhi, and Chairman of the Academic Advisory Board in Chandigarh University, for providing the guidance for the event and for an address filled with profound wisdom and knowledge. I feel deeply indebted to the distinguished speakers, Honorable Professor Tracy Hester, University of Houston Law Center, Honorable Professor Dr. Gitanjali Nayan Gill, Professor of Environmental Law, Northumbria Law School, Honorable Justice Priya Seth Deb, Sri Lankan judge and lawyer. He was the 45th Chief Justice of Sri Lanka and a former Solicitor General of Sri Lanka, for having shared their wisdom with us today. Now, I strongly believe that education, in its most literal sense, is the soul of the society, because soul is something that never dies and is actually passed on from one generation to another. So I think education has the same phenomena, for we can pass it on to the next generations, and hope we do. And I also believe that the audience which are connected with us today are not only going to gain some invaluable knowledge, but also should bear some responsibility to impart on this knowledge to others around them. And an event of this dimension, ladies and gentlemen, cannot happen overnight. There's a lot of effort behind it. The wheels start rolling months in advance, and I just want to thank all the team for their dedicated efforts. And lastly, I just want to thank the student community from India and abroad for being active participants. Thank you very much.
Thank you so much, sir. Now I request Honorable Mr. Justice Vatantra Kumar ji to conclude the session with luster of his insight. My lordship.
Well, I think we have heard enough, and I'm sure everybody must be wanting to get on to the lunch now. So I don't stand between you and your lunch. I only would like to thank Justice Sanjay Kishan Kaul. He is a gem of a judge and a gem of a man. So is Luke. He's been so kind, being broad. He's always never and never rejected by requests so far, and I hope he continues the same. And Gitanjali, Tracy, as well as Justice Dave, I assure you, the moment we hold, and we are permitted to hold globally the conference in June, July, whenever possible, we will request you to come over to this great institution of education, which I think, 5-7 years, you just can't count, but so they have built a name for themselves. They have distinguished dispensation of education. And I'm sure with all luminaries like you being